today I'm going to talk about leasing and lending, and specifically a document or a provision in your lease that's called a subordination agreement. There's also subordination and non-disturbance agreements and attornment, often called an SNDA. Excuse me, SNDA. So the issue here is you're a tenant, most likely in a commercial building, you sign your lease, and then in the future, there's a new loan that's put on the property or there's a refinance of an existing loan. In title work, in priority of your interest, the tenant would then have priority of interest in the real estate as compared to the future lender, because the tenant's rights arose before those of the new lender or the refinance, right? So everything in priority of law is based on timing. So I sign a lease today, there's a new financing tomorrow. The lease is then in priority in its security position ahead of that loan. Well, as you can imagine, lenders and bankers and mortgage companies and investors don't like that. So they want to be certain that you flip that and that the lender is in first priority position. And the way they do it is in the lease and in a separate document. So oftentimes in the lease, there will be some language, very general language about the tenant agreeing to subordinate their interest to that of the lender. So that'd be very common. And every lender will want that. And most landlords will require it in their, if they're sophisticated at all, they'll require it in their leases. And tenants don't see that kind of coming. So then the next step of that is, well, if the tenant is subordinating under the interest of the lender, what happens if there's a foreclosure or something else? So that's where the non-disturbance and the attornment provisions come in. The non-disturbance agreement, part of the agreement would say that, well, if there's a foreclosure, the lender's not going to disturb the tenant's rights in the property so long as they're making their payments, right? If the tenant doesn't pay their rent or violates another covenant in the lease, then the lender would have the ability to evict them, just like the landlord. But as long as the tenant is performing, the landlord and the tenant will recognize each other's rights and not disturb each other in the process. So the non-disturbances, I won't bug you, right? The attornment is, I agree to be bound as a future owner of this building in a foreclosure, or if it gets transferred to somebody else. So the attornment part is a legal agreement. It's a contract. It's part of the contract that says, I'm going to recognize your rights and you're going to recognize my rights. And it ought to go both ways, right? The tenant should recognize the lender's rights and vice versa. The lender should recognize the tenant's rights. That's balanced drafting. And you want to be careful with it. So in a commercial lease, be certain that you've addressed this with your tenant. Or if you're a tenant in a building, you want to be sure that you've addressed it and that you're getting the proper protections. And it would be possible, I don't want to say common, but it's certainly possible that a lease would only have the subordination part and not give the tenant the extra protection of non-disturbance and attornment. Those are key differences and key additional provisions in your lease agreement. And the tenant wants all of those. Now, it's really in I think the landlord's best interest to have all of them, because then that secures your property the best, secures your cash flow the best, makes your property more valuable, and then it's more valuable to the lender, right? Everybody's better off. So just be sure that you've got all this. In your title work and in your leasing, it may be that the title company is going to require a new document at the closing table, and they're going to want the tenant to sign off on a new SNDA, a new subordination, non-disturbance, and attornment agreement, and not rely specifically on what's in the lease. This will go beyond that and give full protection, and that's what the title company wants, to be sure that everybody's covered as much as possible. So the owner's covered, the tenant's covered, and the lender's covered. And we have our own forms in the title company that'll do that and make certain that you've got the coverage you need and that your document is correct. And we've superseded anything that may be improper in the lease itself. So it's going to be in there, and it ought to be on your title work as well. SNDA, that's the topic for today. Thank you, and give us a call if you have a question on that. Thank you very much.